It's also important to note that although the memo restricts the application of these new rules to the filing of a petition, it is possible to see them implementing this at the port of entry as well. We did see in early January a situation where some CBP officers at the airport in Newark had actually denied entry to several H-1B workers, apparently because they were working at a client site. In this situation, several of the workers were subject to expedited removal, which is basically a deportation procedure that is not carried out by an immigration judge. There's no attorney present. Pretty much you're told that the government will pay for your return trip home. It's very important to note that if you are subject to expedited removal and your employee has to return to their home country at the government's expense, that there is a bar to them re-entering the U.S. after that happens. So it is not the result that you want to have at the port of entry. If they're given an option, it would be much safer for them to request to withdraw their application for admission if they're at the port of entry and run into trouble. In this situation where you withdraw your application, you or the employee would be paying for their return ticket to their home country, but you're not subject to the bar to re-entering the U.S. So it's really important for you to warn your employees about the risks of travel, make sure they understand what could go wrong at the port of entry. This is also something that could be implemented at the consulates when they're going for visa stamping. So if your employees do not have an urgent need to travel or an emergency situation, it would probably be safer for them to remain in the U.S. and continue working on the project. So if you're wondering what you can do if you sound like your company falls into the category of example number 2 that I talked about, there are some things that you should be looking at, ways that you can hopefully inexpensively and relatively quickly revise your current business process or business model in order to hopefully comply with this memo and show the USCIS that you are showing the proper amount of control over your employee even though they're placed off-site. So the first example would be to start using employment agreements or offer letters if you're not doing that already. As I mentioned, that is one of the documents they will be requesting in an RFE. You need to make sure that your employment agreement states the salary and the job title that is listed on your H-1B petition. It should be signed and dated before the H-1B petition is filed. And it would be extremely helpful if in the employment agreement you have language in there that states that you as the employer have the right to control various aspects of the work even though the person will be working at a client site. Another thing that you can do is talk to your vendors, or if you have a direct client, talk to your client about revising some of the terminology in your contract. If you can add in a clause to your contract that states that your company has the right to control the worker when they're at the client site, and it's your company that will be assigning the projects, even if the day-to-day tasks may be assigned by the client, it still is helpful if you have overall control over how the work is accomplished. One other thing that you may want to consider, and this would be relatively quick and easy and hopefully free or relatively free, if you're not doing them already, you need to start doing performance reviews. It doesn't need to be on a monthly basis, probably an annual basis should be sufficient. Since it's January, beginning of the year, now is a good time to get it done so that you'll be set for any future extensions that you need to file this year. You can easily find sample performance reviews just by Googling that. And you'll find a list of questions that you can ask your employees and things that you can talk about in a meeting with your employee and document how you feel their progress is coming along, and keep that in your files. Make sure you date it. That way you can submit a copy of it to USCIS when you're asked for in the RFE. In addition, a really important one, if you're not doing this now and you don't start doing it, you're going to run into denials. And that is, you need to meet with your employee on a periodic basis. It does not have to be in person, because obviously they're at the client site, which is usually in another state, and it's difficult to travel back and forth. You can meet online, you can do Yahoo Chat, or just have your employee type up a report of what they've worked on for a week and email it to you. You as the manager review it and approve it, or give your suggestions for how to continue. That way you create a paper trail also, so that if you're asked how are you supervising your employee when they're off-site, you can print out all of your emails and say, I get an email report from them every week and I approve it before they can move on to the next part of the project. So that's something that can easily be implemented. I know it's time consuming probably, but it is going to be very important as you move forward. Another thing that you can do is to, if you're not doing this already, make sure you're keeping your own timesheets. I know a lot of times in the consulting business, it's the vendor that receives the timesheets from the employee. That's fine, but you also need to have your own timesheets. Don't rely on the vendor timesheets for your payroll. You are the company that's responsible for hiring, firing, paying the worker. So if you're going to be paying them, you should have your own timesheets. And you can still have the vendor timesheets, but make sure you have yours as well and keep them on file. That's something you can keep in your public access files as well, or your private access files, which will satisfy the Department of Labor if you're ever involved in an LCA audit. Another thing that you should consider, I mentioned before that in example number 2, where they're talking specifically about a consulting company, in the example it states that that employee is filling a core position of the client. That is usually a staffing situation where the end client needs a particular worker not for a temporary project, but to fill a position that's actually a basic position of the company. So if your website, for example, mentions that your company is involved in staffing and providing long-term placement for core positions, that may lead USCIS to a finding that you do in fact fall into example number 2, and that you don't have the proper employee relationship and cannot file the H-1B for that person. So you may want to consider updating your website. USCIS does do data mining. They are looking at websites and anything that's out there on the web regarding your company, especially your company website. So that's something you may want to consider removing or revising so that you're not focusing all of your services on the staffing area and focus more on the consulting work that you do. Something else that you should be doing if you're not already is providing employee benefits. That is one of the clear factors of showing the employer-employee relationship. So consider medical, dental insurance, 401k is also a good one that's relatively inexpensive. The employer in a 401k is not required to contribute anything. It can be just left up to the employee whether they want to do that or not. So that's also another good option. One of the other tests I mentioned, or factors for determining the right to control, is whether your company is providing the tools and instrumentalities for the job. Now, obviously in the consulting industry, most everything is done on the computer. So the question is, are you the company providing the computer, or is it the client? I understand that the client probably has specific software that they need the employee to work with, but if you have the option, it's more recommended that you issue the laptop. Even if the client has their own laptop, go ahead and issue your employee a laptop as well, because they can be using that for their company emails and to send you those weekly reports that I talked about. So I know that's one of the more expensive options, but that certainly is one of the major factors involved in this test. Also, a cell phone might be another option if you don't want to issue the laptop. A company cell phone that allows them to get their emails while they're on the client site would be helpful as well. In addition, if you do issue the laptop, or even if you don't, you may want to consider purchasing software and installing it for the employee yourself, so that you can show that you're providing the software necessary for that client project rather than the client providing that software. And I'll talk a little bit more about software in a minute as well, because that is another way in order to meet some of the guidelines of this memo.